SJC-11643, Commonwealth v. Sean Evelyn.
Good morning. May it please the court.
Hold on a minute. Got to start the clock.
We appreciate your enthusiasm. All right, now you may proceed.
Thank you. Good morning. May it please the court. I'm Jean Kempthorne. I represent the appellant Sean Evelyn. In opening statement, defense counsel said about his client, Mr. Evelyn, he's guilty of manslaughter.
If his client and he had discussed this and they agreed that was the strategy, no problem, right?
I still believe that a colloquy is necessary.
Where do you get that from? I mean, every case that I've seen, virtually every case that you've cited, these are all ineffective assistance of counsel claims in which at the heart is the fact that the defendant never consented to the concession with his counsel.
That has been, Your Honor, generally what I've seen in many cases is a due process claim is also brought along with an ineffective assistance claim. And the court has gone off on an ineffective assistance claim and sort of buried the due process issue or dealt with it in a cursory fashion. Amicus counsel found various state cases where, in fact, the court was more explicit in dealing with the due process issue. And even though the holding would be a Sixth Amendment IAC, they said you need a colloquy in order to establish the consent. So, in other words, where you are really over the line between tactical and strategic concessions, and you're now at the point where counsel says my client is guilty of a crime, notwithstanding the fact that he has pleaded not guilty.
But that's not a stipulation. That doesn't fall within the stipulation variety. It doesn't reduce the burden that the government has of proving beyond a reasonable doubt with evidence that he's guilty of the crime, right?
Well, not technically, but practically, yes, it does. Well, very much so.
But it happens all the time also.
Well, it happens sometimes, Your Honor, and it's done, I think, with an eye towards, currying favor. But the fact that it's done all the time, I submit, is not a reason to exempt it from this kind of scrutiny. The defendant pled not guilty. And on the record, his lawyer's job, no matter how hard the defense is to honor that. And if they have agreed that we're going to concede to a very serious crime, manslaughter, we're going to say it in opening statement before the government has even had an opportunity to fall on its face, which happens.
Well,
I mean, in other words, there's been no showing whatsoever.
He
Sorry,
pleaded
Judge.
not guilty to the
first-degree murder.
That's right, and that's not the same as saying he can't say that I'm guilty of manslaughter.
Your Honor, that's
that's
true.
very consistent, isn't it?
It isn't consistent because if counsel had come in that morning after the jury had been impaneled and said, look, my client wants to now plead to the manslaughter, we would not be dispensing with a colloquy.
Okay, but
and it wouldn't matter.
But maybe he knows that that's not going to work, and so this is his only option. The prosecutor isn't interested in taking a plea or offering a plea to manslaughter.
But that wouldn't be the test, whether the prosecutor is willing to take it. The issue would be, and what the court would be looking to be sure, is whether or not the defendant understands, not just that he's agreed to this, but that he understands the ramifications of doing so. For example, what the maximum penalty is, what various likely results are to this. Even if there were consent, and this is why I say it shouldn't turn on consent, but rather whether or not the consent is knowing and voluntary. So I say you need a Boykin colloquy.
So do you need a Boykin colloquy if the defendant decides to testify?
The law is that you do not, and that is...
Even if he intends to say, I'm guilty of manslaughter, but I certainly didn't intend, I was caught up in the passion of the moment.
Well, the right not to testify or to testify is really two rights. And the concern that the courts raise on whether or not the judge should counsel the defendant is that it's an awfully thin line between appearing to advocate for one side or the other when they are both of constitutional dimension. Whereas here, the statement, I'm guilty, or my client is guilty of manslaughter, and saying it in opening statement.
So that makes a difference, saying it in opening statement versus closing statement? You wouldn't have to have a colloquy at closing?
I think you do, but you don't have to reach the issue here. The answer is, yes, I believe you do, except perhaps in a death penalty case. I do think the law recognizes that death is different in this context as well, and Florida v. Nixon, is decidedly...
We don't have the death penalty, so we don't need to deal
That's
with
right,
whether that's different.
but in other
what would
words,
the colloquy
many of
look
those
like?
cases...
Tell me what the colloquy is. He's not waiving his right to trial. He's going to trial. He's not waiving his right to confront witnesses. He is confronting witnesses. So what's the colloquy going to sound like?
The colloquy is going to be actually, I think, very close. It's going to be, are you aware that your attorney is going to concede that you were guilty of manslaughter? Do you understand what the elements of manslaughter, or has your attorney explained to you what the elements of manslaughter? Do you know what the penalty is for the crime of manslaughter? In other words, Judge, I think it is going to look rather similar to the Boykin colloquy, but it will be with respect to the manslaughter crime instead of murder one.
Isn't the idea of when things are, for instance, stipulating to facts, and in other cases where it isn't a formal plea, but this court has said you need to treat it as such. But isn't the underlying reason is that the government is not going to be required to prove anything beyond a reasonable doubt?
I don't believe that that's the case, and I think here, Your Honor, really, once counsel has said in opening statement, my client is guilty of, what is that concession? That concession is that the homicide occurred, that the defendant was present and responsible for that homicide, that the homicide was unjustified, and that the defendant is criminally responsible for it. Self-defense is off the table. All sorts of defenses are now really off the table. Let's be practical
But
here.
suppose there is nonetheless evidence at trial that emerges of self-defense and, or other matters. The government can't simply rest on the concession, right? The government still has to put in evidence, including evidence that would show that the self-defense was overcome.
The government, I believe you're right, Justice, would have to put in at least a prima facie case. I think the argument about reasonable doubt is now gone because there has been such a concession. It's very hard to see.
If the evidence were not sufficient, the judge would still have to grant.
I think that's also true. But nonetheless, it's such a powerful statement by the defendant's own mouthpiece in the face of his plea of not guilty. And I don't believe that the court should establish a rule that looks behind what happened in court that day. But look at the facts here, where the defendant twice did not go forward with a plea. And
But as I understand from the record, it wasn't on this part, it was on the drug counts.
Well, but then there's a whole long period of time where he gets new counsel, and months and months go by, Justice, before the plea is taken off, the offer's taken off the table. And we don't know what's going on there. But in fact, it isn't for months, and that's part of the record.
Isn't that the kind of record you develop in the context of an ineffective assistance of counsel claim? It seems to me that this is exactly where this kind of stuff falls.
Justice Cordy, I am willing to concede that in many cases, and perhaps this case, trial counsel thinks a concession is the best he's going to be able to do, or she is going to be able to do. So I am not going to bite off and don't think this court should either. The fight that you see fought in other jurisdictions between how would you show prejudice, is this a chronic standard, is this Strickland?
But
I mean, how are you going to do that?
Surely one could argue, I mean, let us assume that the attorney says, I actually didn't consult with my client about this, but in my professional judgment, this concession was important to make. Well, one could argue, as many have successfully, that making such a concession without consulting with one's client is ineffective assistance of counsel.
But now you are getting in between what the client and the attorney-client relationship, and I think it's unnecessary because you still don't know whether that consent is intelligent, and you don't know whether it's voluntary. And you're going to have courts, as Florida v. Nixon is one, where there's no question of consent, and it's looked at as this is something the trial counsel is doing in order to protect his client's life. In other words, I don't think the IAC turns on the consent, Justice Cordy. I believe
Florida versus Nixon says even if it's unconsented to, that's not per se ineffective assistance of counsel. A lot of state courts have said otherwise.
that's correct, and that's, of course, that death is different issue. So coming back down to it, I started off by saying really the courts have kind of dovetailed the due process issue with the IAC issue. Lawyers have, I think, maybe appropriately or maybe not wisely, raised both issues. And the court comes up with what looks like a sort of due process remedy. In one case, Boykin itself, we're going to have a Boykin colloquy, or something like consent, which again looks a little bit like due process in order to solve this issue, which I think fundamentally is who gets to make this decision.
If the lawyer had argued, instead of saying my client is guilty of manslaughter, had said my client killed him, didn't use the word guilty or the name manslaughter, but went through, conceded a whole bunch of facts that actually would equal manslaughter. Would that be okay?
Well, I don't think if it equals manslaughter, it's okay. But I do agree that some concession of facts is within the tactical and strategic realm. In other words, it's within counsel's purview. The question I'm really posing is whose business is it to decide to agree that the defendant is guilty of a serious crime? And that's the language counsel used here. And I submit it's the defendant. It's not counsel's purview.
I understand that many judges, at the close of the Commonwealth's case, would ask the defendant, would make sure they know that they have the right to testify, and if they decide not to, that it's their choice. But that's really more not because of a required colloquy as much as to make sure that there's no claim later on that I didn't know that. Isn't this really isn't this ineffective assistance of counsel issue, and you're doing a colloquy to address the possibility, as Justice Cordy mentioned, that the defendant was not consenting to this course of action?
I don't believe so. I think it is such a serious concession, even though, as Justice Botsford pointed out, there's still the requirement to put in a prima facie case enough to get to the jury. The concession is so significant that there should be a full-blown colloquy.
But the full-blown
And I
colloquy,
think the
if
right
you're going to go into the issue of was it intelligent, isn't that going to go into the issue of strategy?
No, I think the intelligent goes to whether or not the defendant understands the elements, whether he understands the penalty, whether he understands the likely consequences of a plea. That's what I think we mean when we say an intelligent plea, is that the defendant, the court assures itself, understands the likely consequences of the plea, including the penalty.
So the judge would say you should understand that if at the end of this trial the jury does find you guilty of manslaughter, you would face the following penalty. Is that sort of the way it goes?
I think it should.
Because he's not facing that penalty now just because his lawyer plans to make a concession.
At the beginning of the trial, after the jury is impaneled and there is always a bench conference about what's going to be done or said. Defense counsel says, Your Honor, I want to make a concession. I'm considering making a concession. There would be a voir dire with the defendant. I don't think this is onerous or difficult. I don't think it's intrusive in the least. And I think it would go into precisely what I said. It would be, this is what the concession, did you discuss this with your lawyer? Are you satisfied that he's acting in your interest? Do you know what the penalty is? And so forth. So,
But you're saying that it requires a new trial even if there is no claim, as you've made no claim, that counsel was ineffective in doing so.
that's right. I'm assuming here that counsel has very good reasons for doing what he or she is doing,
And we have no affidavit from your client that says, I didn't consent to this.
because this is not an IAC issue, and you don't go beyond the record in looking at whether or not the concession of guilt. This is a straight due process analysis. There would be no affidavit. It wouldn't be necessary or appropriate. You would look at it straight as a, were the requirements of Boykin, does the court have an assurance that the plea or the, I'm not even going to say tantamount to a plea, I'm going to say sufficiently like a plea to warrant adherence to due process standards, to make sure that the defendant knows what his lawyer is about to say as his mouthpiece. This is as if the defendant himself is saying it.
Thank you.
Thank you, Your Honor.
Good morning. If it please the court, Donna Petalano on behalf of the Commonwealth. Chief Justice Gantz, you took the words right out of my mouth. How would you even craft a colloquy here? He's giving up no rights whatsoever. He has a right to a jury trial. He is actually exercising it right after the opening. He has the right to confront witnesses. He does confront the witnesses. He has the right to the presumption of innocence. He has a right against self-incrimination. In fact, the judge here did have a colloquy when the defendant opted not to testify. So he's giving up none of those rights.
But isn't the argument that there's a waiver of the right not to incriminate himself?
That's the argument, Your Honor. But if the statements in opening are not, in fact, a stipulation or admission to sufficient facts, he's not providing any evidence against himself.
What's the provision of evidence against yourself that you say, as opposed to, I concede that there would be evidence amounting to? Isn't that the equivalent of a plea, basically saying he's guilty of manslaughter, is that the evidence you'll hear is going to be sufficient?
No, in fact,
Establish
if the Commonwealth had
manslaughter.
rested after the opening, there would have been a directed verdict in favor of the defendant here. There would be no guilty verdict here. And the other issue is the verdict here was second-degree murder. In fact, he wasn't even found guilty of what he conceded to. The government had to disprove beyond a reasonable doubt the reasonable provocation, or that he was acting in passion. The jury instructions here were clear. The evidence is not what happens in the opening or the closing. Just focusing on the opening here, they were told at least twice that openings, actually 3 times, openings were not evidence. And it isn't evidence here.
But that's just so impractical. I mean, if the defendant's attorney gets up and says, my client is guilty of manslaughter, as a practical matter, that would be the kind of thing that the judge would have to give an instruction on to wipe that clean, wouldn't he?
No, Your Honor. The judge does not have to instruct on that, because the instruction that he has already given is that the openings are not evidence. And in fact, the instructions then go on to say, laying out all the elements of first-degree and second-degree murder and manslaughter. And the jury has to be presumed to have followed those instructions. The Commonwealth was put to their burden on every single element here. And in fact, beyond what, as I said already, beyond what the statements were in the opening, had to prove beyond a reasonable doubt that there was not provocation here to act.
Well, I guess I just mean to say that it's just really technical to say that you can rely on the judge's instruction that what's said in the opening statement is not evidence to wipe away the prejudicial effect of that kind of statement. That's all I mean
Well,
to say.
I wouldn't agree, Your Honor, respectfully, that it is prejudicial, because the counsel, when he stands up, also understands that if he were not to concede some of the facts here, would completely lose credibility in the eyes of the jurors. The jurors are the fact finders here. And if counsel were to get up and argue something other than he did, I think he'd be losing face in front of this jury.
That's a strategic question, though.
Yes.
That's not exactly what Justice Hines was getting at. Is sort of wiping the slate clean by an instruction is a little difficult in these circumstances. Pay no attention to that concession, madam, ladies and gentlemen of the jury, right? I mean, it is powerful. This is powerful for the lawyer to get up and say, you're going to hear evidence that my client is guilty of committing this homicide.
It's absolutely powerful, Your Honor. When you're considering the type of evidence that this counsel was facing, he had to make a powerful statement in the opening, and it was a reasonable strategic decision to make that powerful statement. The other, the reason why I think that this court has not really delved into the due process issues that my sister raises is because ineffective assistance of counsel through a motion for new trial is a protection of the due process rights here for the defendant. That's how he is able to protect his rights for due process. Here you have an attorney who, and for one of the reasons why I think you should disregard the amicus brief here, the amicus brief says that everything is done here without the consent of the defendant, and you don't have anything in the record that says that. I would argue that the absence of that is it leads
Shouldn't we
credence
just
to the-
leave it, we don't have it, period?
Yes, you don't have it. But what you do have is a record of a defendant who came before judges twice before to plead guilty, who opted not to, in both those, after going through a whole colloquy with Judge Laureate, opted not to plead guilty, who tried to fire trial counsel a month before or 6 weeks before the trial actually happened. This is a defendant who is well involved with the litigation strategy that he is putting forward. When my sister asked, whose business is it? The business is the business between the attorney and his client and their relationship. At what point would you stop colloquies if we were going to have colloquies before a concession is made? Would you have a colloquy when he opts not to cross-examine a witness who has provided evidence on an element of a crime? Would that require a colloquy? Would you have to have a colloquy when counsel asks for jury instructions?
This is a little different level than that. I mean, this doesn't happen all that often where counsel gets up and concedes a major felony.
Well, Your Honor,
It
why is...
happens, I know,
Yes.
because sometimes that's the only thing you've got.
But why is it any different than the time when counsel asked not to have a manslaughter instruction? Because he is rolling the dice, essentially, and going for first-degree murder, doesn't think the Commonwealth has proved that for first-degree murder, and opts not to have an instruction. You see those cases all the time. They come before you on ineffective assistance of counsel. Does the judge then have to have a colloquy with the defendant?
Again, that is different. I mean, this is a concession in front of the decision makers, the jury. This is different than a technical question of whether he wants a voluntary manslaughter instruction as part of a... I mean, that just seems different.
Well,
the jury's not going to know that. The jury's not going to know, aha, defense counsel has not requested a voluntary manslaughter, therefore he must be conceding same.
Well, Your Honor, what the jury does know is that they then have to sit through 5 days of evidence, that they are told by the judge multiple times that they are the finders of fact here, that their memory controls, and that they need to consider the evidence and all the different types of evidence, but not openings and closings, certainly, not the way the judge has commented, not objections, not questions. They're given a very long information about what type of evidence they can consider, and openings do not fall into that. The defendant has his protection here. The attorney was not currying favor when he of the jurors when he made these statements in opening. He was facing a very difficult case where the defendant wanted to go to trial and really had no other option but to try and mitigate the finding here.
Well, would you
Let me see
agree
if
with... Go ahead.
Let me see if I understand. Suppose, I think Justice Botsford asked this question before about, suppose the concession had not been as to guilty of manslaughter, but throughout the opening and or closing, defense counsel essentially conceded facts that amounted to the same thing. Are you saying that that too is not a problem? And that would be because because the instructions would be that nothing that counsel says is evidence,
Yes, Your Honor.
including saying, don't, this, he did this, he did this, he did this.
And focusing specifically on the openings, because it's before the jurors have heard any of the evidence, that where it's not an admission to sufficient facts, and the jurors are the finders of the facts, they sit through the evidence, they sift through the evidence, and they're the ones who determine whether the Commonwealth has met their burden, and the Commonwealth is still obligated to meet their burden on every single element of the crime here. And for all of those reasons, there should not be a colloquy in this
You said
instance.
that there should not be a colloquy. Wouldn't you, as a prosecutor, want there to be some colloquy in this case? Because if there isn't, you may face upon the conviction the claim on appeal, the counsel was ineffective because I had no clue that he or she was going to do that, and therefore I was denied my right to trial.
Well, Your Honor, I mean, certainly we do ask for colloquies frequently for the jury instructions when there's a request not to have a manslaughter instruction. Here, though, I think, first of all, defense counsel would have to give us a heads up about what their theory of the case is going to be, and that may in itself be ineffective assistance of counsel. So I can't imagine an instance where we would want to delve into that relationship between the defendant and his client in order to have the colloquy, short of what the jurors are able to consider through the instructions of the judge. And the concession here did not take any consideration that the jurors had off the table. They still had to consider every single element of the crime, and in fact disregarded the concession here. And I think that is the most telling fact that came from this trial.
They disregarded the concession to find him guilty of murder?
Manslaughter.
Right, but they found him guilty of murder too, didn't they?
Right, because the Commonwealth had to prove beyond a reasonable doubt that there was an absence of provocation here. So the concession was disregarded by the jurors here.
Yeah, well, not really.
They had to find he killed him, too.
Yeah.
Yes, that's true. That's true. But the fact is, they didn't find him guilty of murder because of the concession. It was because of the multiple witnesses who came before, because of the eyewitnesses who saw him chase Cushing-Fontana down the street and shoot at him 5 times, hitting him twice as he lay on the ground. I mean, when you have eyewitness evidence that is that powerful, it's very difficult to craft an opening or a closing that doesn't concede to some of the facts that the jurors will then hear without losing credibility in front of the jurors and asking, in this case, for some mitigation of the finding of guilty in first degree, which they did. And if there are no further questions,
Thank you.
thank you.